Hello everybody, I'm Father Robert Spitzer. I'm going to be talking today about an objective case for the inalienable rights of preborn human beings. What that means essentially is that every human being has the inalienable right to life, even if that is a human single-celled zygote. I think the case can be made in 4 steps. The first step concerns the biological case for the humanity of a single-celled zygote. The second concerns why every human being must be considered a person deserving of rights under the law. The third step of the case concerns why every human being, that is to say every person, because every human being must be a person deserving of rights under the law, why every human being or person, why they have the inalienable rights to life, liberty, and the pursuit of happiness and property. And finally, why the life rights of the human zygote outweigh the liberty rights or the privacy rights of the mother in a rights conflict, the so-called natural hierarchy of rights. So that's our fourfold task or purpose of this video. Let's quickly go to the biological case for the human being, the first step of the argument. As most of you know, during Roe versus Wade, in that decision, at that time, the biological evidence was not set as it is today. Today, it is an indisputable fact that a single-celled human zygote is in fact a human being, and let me just give you a sense of the evidence for that. There is an excellent amicus curiae brief to the Supreme Court for the Dobbs versus Jackson Women's Health Center case that's now before the Supreme Court. In that amicus curiae brief, which is really an excellent brief with excellent evidence, there was a review of the biologists. First of all, they make the case that the people who should be answering this question are really biologists. In other words, if you can establish biologically that a single-celled human zygote is a human being, then the philosophical arguments are almost a moot question at that juncture. So we should probably accede to that definition within legal parameters, within the legal framework of the not only the Supreme Court's interpretation of this particular case, but as a matter of course for all legal cases going forward. They have done a masterful job in this amicus curiae brief to show this. In one large international survey with, I think it was 5,500 different biologists. These are people generally with PhDs in biology, or they are bench scientists in the biological area, most of them teaching at universities. 96% of the international survey agreed that that a human being comes into existence, a unique, specifically human being comes into existence at fertilization. Now, there are other competing definitions, but 96% in the international survey agreed with this. A subsequent survey was put out in the United States proper, where I think you can see that the percentage is still a supermajority, but it's lower than the international survey. And I think the reason for that is it reflects the politics in this country more than the science. But let's just go through really briefly what the survey indicated and what most biologists indicated. So 68% of the biologists, and by the way, you can go to the appendix of this amicus curiae brief. You can see all the scientists and biologists who certified this themselves. But anyway, 68% of the biologists said that fertilization was the indisputably objective way of determining the beginning of a new specifically human, a unique, specifically human being. So that would be 68%. About 12% of those asked indicated that it was the first breath of a human being. Of course, that would be outside of the womb. And so 12% indicated that. Again, if you reverted to that definition, basically viability wouldn't even be considered a human being. That would be a definition that goes back to the 1800s, really. And there's no reason to reject what's called the genetic-based method for determining the existence of a human being. There's no reason for that. It's gratuitous, really, to say that. But 12% of biologists said that that's what they preferred in the U.S. 10% said they preferred the viability standard. That is to say that when a fetus becomes viable at 24 weeks now, but of course a viability standard is completely dependent upon the moment in time and the country in which that occurs. So yeah, today it's 24%. When Roe versus Wade was written, it was 27 weeks. Now today it's 24 weeks. It's going to become obviously lower and lower and lower. And when finally we have an artificial womb, it will be the single-celled human zygote will be able then to be classified by that criterion as a human being. So that's a subjective standard. It's flexible. It's not an objective standard, as is the biologically based, the genetically based criterion. And finally, a third group, 10% again, of the biologists said that they preferred a standard of the first heartbeat or the ability to feel pain what is this, about 8 weeks or so in a human being. But again, the standard is essentially a subjective standard, because why would it be that and not something else? So the point though is 68%, which is a supermajority of biologists, still say fertilization, the single-celled zygote, is the best method. It's a genetic-based method for ascertaining the beginning of a human being. Why is that? Why did a supermajority in 60% in the American case, 96% in the international case? Why was that? Because of two reasons, actually. At the moment of fertilization, you have a complete, unique, specifically human genome. So a new, complete, specifically human genome. Every single, when you have the pro-nuclear fusion that takes place, right, that completes the unification within the fertilization process. When that happens, the new human being's genetic structure is determined, which will, of course, be the instructions which will occur not only within the human being to develop it throughout its life cycle within the womb, but outside the womb as well. So that's the first reason. The second reason is because a single-celled zygote, this cell, the zygote cell, is a very unique cell, right? It's a developmental cell. It's not like a skin cell, a heart cell, muscle cell, right? In a human being that's oriented toward one function alone, but it actually will be the foundation, the origination of every single cell in a human being throughout the course of his lifetime. That single cell will be the origination of all other cells in a human being throughout the course of the human being's lifetime. And that zygote cell is going to become the unity of all of those cells in a human being throughout his or her lifetime. So when you add these two factors together, it's pretty clear that you have not only a complete human being there, you have a full, unique, specifically human being, what we'll call a complete human substance at the stage of a single-celled zygote. Now, what does that mean? That means that the stage of development of a human being can't overrule the humanity that's this substantially human being that is present at the single-celled zygote stage. So it doesn't really matter what the stage of development is. That being is human, indisputably human. So, for example, a single-celled zygote is not only indisputably human, but a fully developed human being at 9 months, let's say, which is not really fully developed. The human being continues to develop all the way through adolescence. Right, the frontal cortex is still developing at 17, 18 years old, etc. So the point, of course, is though that at 9 months, this human being that's about to be born is not any more human than the single-celled zygote. So, you can't say that an accident like the stage of development, an accident like height, or an accident like racial characteristics, or an accident like, the weight, et cetera, can overrule the humanity, this human substance that's present at the single-celled stage, the single-celled zygote stage. So if that is the case, then we can say, essentially that, this is a full human being. It's not ever going to become more human throughout the course of its development, throughout the course of its aging after it is born. It still remains human with its specifically human genome, its specifically human zygote, that still continues to originate cells and unify cells throughout the course of that human being's existence. This is why that 68% of biologists think fertilization is the indisputable point at which a new unique human being comes into existence. This is why 96% of the international survey thought the same. If you want to take a look at that, all you need to do is go to supremecourt.gov and then take a look for the Dobbs versus Jackson Women's Health Center amicus curiae brief on the biological case for humanity. It's really excellent. If we accept then that the biologists have the right to determine when there is a a human being present according to biological criterion, then I would say that right here we have a very good objective case based on the genomic structure, based on the specifically unique kind of cell that a human zygote is. We have a very good case that this is objectively a human being at the single-cell zygote stage. Okay, let's go then to the second dimension in the argument. If we really do have a human being present according to genetics-based biological criterion of a human being, if that's really present as we saw in the first step, then our second step is, can human beings be classified as non-persons? What we see, interestingly enough, is that for many, many years, the word person in French and its development within the common law in English-speaking countries, we can see that for about 500 years, the idea of personhood was always linked to the existence of a human being. However, when the slave trade began to come into real prominence in the 1400s, what we see is suddenly there is a desire to differentiate between a human being on the one hand and a person, now called a legal person, deserving of protection under the law. So we see now that there's a distinction being made in order to accommodate the slave trade. And why was this being done? Because in the law, if a being, a thing, a substance is not a person, it is by definition a property. And in the particular case of slaves, it was chattel. In other words, it was movable property. And so why movable property? Because that means that you could dispose of the property as you wished. You could sell the property as you wished. So it was essential to make sure that these African-American human beings. They were obviously human beings, right? And today, of course, is indisputably genetically based human beings, right? You could see that it was necessary to do this in order to sell them as slaves. Now, in the United States, this officially became law in 1640 in a Virginia statute where black human beings, African-American human beings, were classified as non-persons. So that made them chattel, essentially property, movable property that could be bought or sold or disposed of according to the white property owner's desires. Now, of course, this very same idea of personhood backs up into the Dred Scott decision, Dred Scott versus Sandford decision, where the unanimous Supreme Court held that African-American human beings should be subordinated to the will of the superior, that is to say, white race. So I'm not kidding. This is written right into the decision itself. Now, if that is the case, we can see the danger, the inherent danger of ever separating personhood from human being. And so we simply cannot do. There are two major consequences that come from relegating human beings to property. Number one, obviously, when you relegate a human being to property of another human being, to a thing, to basically, you're taking away their human status. You're reducing them to not just slaves, but you're reducing them to property that can actually be killed. And since they're property, why, you could actually sell fetal parts. That would be justified. After all, the fetus, if it's a non-person, as the Roe v. Wade decision implies in Section 9A, where it says that there are these human beings. Well, they're not going to call them outright human beings, because the Supreme Court at that time, in the majority in the Supreme Court, said that the humanity of these preborn human beings was still up in the air, was not determined at that time. Today, as we saw from the surveys of biologists and saw from the biological evidence, it's indisputable that fertilization marks the point at which a new human being begins. Now, even still, personhood is denied in Roe versus Wade on the basis of the ambiguity of the humanity of that person. But still, what happened? You can see that it was, of course, legal for 20 years until 1993 for fetal parts to be sold at a profit, for fetuses to be experimented upon, et cetera, et cetera. So the idea, right, of separating human being from a person deserving of protection under the law, this is really something that is always going to produce a violation of the principle of non-maleficence. I'm going to just pause for a second and talk about this fundamental principle of non-maleficence. We've all heard of the golden rule, do unto others as you would have them do unto you. Now that's called ethical maximalism. But the silver rule is far more basic. It's in every culture, it's in every religion, and it basically goes, do not do unto others what you would not have them do unto you. You can see this mentioned in the Old Testament. And of course, Jesus ups the ante. He basically takes the not out of that. But let's analyze those two statements, right? Do not do unto others what you would not have them do unto you. Don't do a harm to others that you don't want done to you. Avoid unnecessary harms. But if a harm is unavoidable, then minimize it. This is ethical minimalism. If this falls, then Thomas Hobbes is right. Life will be inevitably brutish, ugly, and short. So this is, the one standard that I think everybody ethically must hold to is the silver rule, the principle of non-maleficence: do no evil, do no unnecessary harm. And by the way, if you know someone who says, I really have to do harms to others in order to feel good about myself, I really need to do unnecessary harms to others in order to be fulfilled in my life, my thought is just run, Bambi, run. What you have here is a conscienceless sociopath. So the point now comes down to what happens when you separate personhood from human being. You get gross violations of the principle of non-maleficence, gross violations of ethical minimalism. You are going to do unnecessary harms, not only to individual human beings, but also to whole groups of human beings, as we saw occurred with Dred Scott versus Sandford, as well as also the Virginia statute in 1640 in the United States, and the multiplicity of statutes in England and prior to that that were trying to justify slavery on the basis that certain human beings were not going to be considered persons and therefore chattel property under the law. Enough said. This is pretty much I think, an ethical, minimalistic statement. From the vantage point, if we're not going to have gross violations of the principle of non-maleficence, the most minimal principle of justice and ethics, you have to consider every human being a person. Relegating certain human beings to chattel, to movable property, of course, is going to create violations of the principle of non-maleficence. Let's go to the third step in the argument. Now, since every human being must be considered a person, we can just say together, every human being, every person, it's the same to make those two statements, must have, by their very nature, the inalienable rights of life, liberty, and the pursuit of happiness. So let's just quickly go through it. There are extrinsic rights and there are intrinsic rights. An extrinsic right is one that's declared into law, say, by a constitution. We, the people of the United States, guarantee this Bill of Rights. Bam, 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 bam. Okay, that's declared into existence by a government, by a plebiscite, by a constitution. Okay, those are extrinsic rights that are given by a government to this body of people. The body of people say that everybody deserves these rights. Not so with inalienable rights. Inalienable rights are natural rights. They're intrinsic rights. They belong to every human being by their very human existence, by their very human nature. And what are these inalienable rights? Inalienable rights just simply means, and this goes back to by the way, a Catholic priest, a Jesuit by the name of Francisco Suarez in 1612, in a work called De Legibus. But the main thing here to remember is that every human being deserves, every person who's deserving of protection of the law, at the very least, must have minimal justice done to them. What is minimal justice? The absolute minimum standard of justice for that every human being deserves in virtue of the fact that they're human and therefore they're persons. What is it that they deserve? Number one, they deserve life. Yeah, if you don't have life, you can't be a human being. You can't act like a human being. You have to have life in order to be human. Secondly, you need freedom. You need some sort of custody over yourself. Not just self-determination. You need, the ability to be self-governing in some sense. That's what it means to be human. We have free will as human beings. We're self-conscious. We have intellect. And with intellect and self-consciousness, of course, we need the ability to determine who we will become. We need the ability to govern ourselves and not be completely governed by another or enslaved by another. So that's pretty clear. In order to be the same thing with property. If I don't give you the right to own some property, some form of domicile, right? If everything that you use and are need in your life is owned by something else, you're reduced to what's called indentured servitude. So you need some kind of property, at least to have some autonomy, enough to be free, enough to have self-determination and self-governance. And finally, of course, you need the ability to perfect yourself, what's called the pursuit of happiness. This is a topic that's a little too much for today, but basically happiness meant the objective that will bring your life to fulfillment. So it's the same thing as the ability to perfect yourself. So these are the basic characteristics since the time of Suarez that have been recognized by all philosophers of law, which gave rise to the inalienable rights doctrines and to the constitutional forms of government that we now see today. Because Francisco Suarez, right, he basically gave rise to the definition that Hugo Grotius, right, Grotius was the father of international law. Hugo Grotius read Suarez, he integrates it into his volumes on international law. Then Thomas Jefferson, John Locke certainly reads Hugo Grotius and puts it into his second treatise on government. Then Thomas Jefferson comes along, reading Hugo Grotius, and John Locke puts it into the Declaration of Independence with the encouragement of Benjamin Franklin. And finally, of course, we see that it winds up in the International Charter for the United Nations International Charter on Human Rights as well. So all of these things come together. Why? Because these are naturally known principles. And that's why Thomas Jefferson is right on the mark. We hold these truths to be self-evident. We don't need any kind of a government to declare inalienable rights into existence. Every human being has them by their very nature. That's why they're self-evident. That's why they're not in the Constitution. Don't see inalienable rights in our Constitution. The Founding Fathers are smart enough to keep them out. Of course, they're in there in the 14th Amendment with respect to no state shall violate the inalienable rights of somebody. But, of course, they're in is the protection of inalienable rights from a state who's gone cattywampus. Okay, now the main thing that we want to notice is because a state never declared these rights into existence, they have no right to declare them out of existence. They belong to human beings by their very nature, and only they can only be compromised when human beings forfeit those rights themselves because they did not they violated the rights of somebody else. They killed somebody else. They took somebody else's freedom away, etc., etc. So what must we conclude when we see this? By the way, you can always tell an inalienable right from a non-inalienable right. For example, the Supreme Court says that abortion is a legal right. Well, if it's a legal right, it certainly is not an inalienable right because you don't have to have an abortion in order to be human. Right? Again, slavery. This was considered a legal right by the Supreme Court at one point. And again, it couldn't have been an inalienable right because you don't need to own slaves in order to be human. You don't need a cell phone in order to be human. The only thing you really need is the capacity for, of course, self-preservation, then self-determination / self-governance, that's freedom, and self-perfection, and the ability through property to avoid indentured servitude. Okay, so now we can pretty much see then, well, if you're a human being, and therefore you're a person deserving protection under the law, you at least deserve minimal justice. Everybody owes to everybody the capacity to have minimal justice shown to them, to have the ability to preserve their life, to govern their lives, to perfect their lives as a human being. We have to have that minimum justice, for every human being. Okay, and no government can declare those out of existence unless somebody commits a criminal act and violates the rights of somebody else. All right, there's a natural hierarchy of rights, and this is my last topic. Finally, the idea for the natural hierarchy is simply this. If a right is necessary for the possibility of another right, then the right which is necessary must be the right of that is more fundamental. That's a higher right. So the right to life is necessary for the right to liberty. Well, why? Because if you're dead, your liberty rights are a moot question. Of course, the right to life is necessary for the very possibility of the right to liberty. Same thing with the Dred Scott decision, where it was decided that a white person's property rights were more could outdo the liberty rights of black Americans. And so you take a look at that for a second, you go, wait, that doesn't make any sense. Because, of course, if I say that your liberty rights, I say, oh, you have all the property rights you want, but I get to own you. Well, de facto, right, I own all your property rights along with your self. And so, of course, liberty rights have to be higher than property rights. Liberty rights are necessary for the very possibility of property rights, etc. Okay, so when we take a look at this natural hierarchy of rights, why do we bring it out? Because the only way you can have an objective criterion to resolve rights conflicts is if you evaluate one right as higher than another right. So, for example, we can see that in Roe versus Wade, right, it's the rights to life of the fetus, the right to life of the preborn versus the right to liberty of the mother. The objective hierarchy of rights requires that the right to life of this human being, this full human being, right? There's never going to be more human, no matter what its state of development. Its humanity is already intact at the single-celled zygote stage, according to the nature of the zygote cell itself and the human genome. So if that's the case, then the decision must be accorded to the fetus. Let's go to our summary now and take a look very quickly at the summary of the argument, and you can pretty much see what it is. Let's take a look at number one, the biological case for the humanity of a single-celled human zygote. We took a look at what the majority of biologists said, 96% in the international case, 68% a supermajority in the U.S. case. We took a look at why the supermajority of biologists say this. It's because of the nature of the zygote cell being the foundation of all other cells, the origination of all other cells throughout the course of a human being's existence, whether it be a man or a woman, and also because the full, complete, that is to say, specifically human unique genome is present at the single-celled zygote stage. So that everything is in place to be a full human being. That's the reason for it. Number two, we also saw that every human being must be considered a person deserving of protection under the law. If you don't do that, you're going to if you deny that principle, you are going to definitely create a condition for violation of the principle of non-maleficence, the silver rule, ethical minimalism, do no unnecessary harm to another human being. So you're going to violate that for sure. And number two, you're going to relegate a human being to chattel property, to basically non-personhood means to relegate them to property that can be disposed of as anything rather than a human being that will, obviously be self-determinative, self-perfecting, etc. Finally, if that's the case, if that's the case, then that personhood, the human being and now known as a person, must have inalienable rights by their very nature, must be deserving of protection not only under the law, but must be deserving of minimal justice. And that minimal justice, in turn, requires life, requires the ability to be self-governing, requires the ability to be self-perfecting, requires enough property to avoid indentured servitude. That's what you need in order to be human. Every human being, which is a person deserving of protection of the law, must have that minimal justice by their very nature. This is not guaranteed by a state, so no state can take it away. And finally, in the case of any rights conflict, the higher right must always trump the lower right. The right to life is necessary for the possibility of all other rights. Therefore, the right to life must be higher than all other rights. It must trump all other rights in a rights conflict. Well, thank you so very much for your kind attention today. This pretty much is the case, I think, an objective case for not only the humanity of a preborn human being, but for the inalienable rights of a preborn human being, the rights to life especially, which trumps all other lower rights. Hopefully this will bring about a reversal of the Roe versus Wade decision, because I think all the objective evidence biologically and legally points to it. And by the way, ethically as well. Thank you for your kind attention. I'm Father Robert Spitzer.